All right, now we are still in week 7 or topic 7, the First Amendment, but we're moving on to the provisions of the First Amendment that deal with freedom of religion. The language here, again, it's with the language here with freedom of speech, is incredibly simple, incredibly short, and very few words. The writers of the amendment covered large parts of our social, religious, and political life, and basically set down a rule that we keep investigating and we keep making decisions based on how things and times change. But the basic language of the amendment has not been changed in 200 years, nor is there any real great impetus to try to change it. The language is, again, very clear, very concise. Congress shall make no law respecting the establishment of a religion or prohibiting the free exercise thereof. That's it. Simple. Very, very simple. Complicated in figuring out how it applies to society, particularly as society grows and changes and moves along over the years. Um, Basically, what this does, and what the courts have done with this, if they've taken this language and they've broken it down into two different sections, and they deal with them a little bit differently. Um, the first part of this is called the Establishment Clause, and it basically says that Congress shall establish no religion. This is in contrast to what had gone on in England, and again, we've talked about this before, where many of the colonies were established by groups of people who had religious beliefs that were different from the King of England. And in England, in the time of the 17th century, when the colonies were established, under penalty of death, you had to follow the religion of the king, which actually changed from time to time in its practices, its beliefs, and whatever. And if you didn't go with the flow, you could be subject to imprisonment or death. And the religion of the king was the established religion. It was combined with the government. It was part of the government. Contribution or tithing to the churches was mandatory, just as taxes were. Attending services at many times were mandatory. Participation in the religious life that was supported and established by the government was a requirement. And so the colonists, particularly in the writers of the Constitution of this new country, did not want that to be the rule, and in particular because the various religious groups moving from state to state were incredibly different. Even at that time, there were many variations, and they wanted to make sure that the new government would not attempt to favor one group over the other or to establish its own brand of religion as the official government religion. The second half of the clause is called the Free Exercise Clause. And what that has come to mean is that individually, any person can believe or practice whatever religion they choose, or to practice no religion at all if they so choose. It was also a death penalty to be an atheist in 17th and 18th century England, as well as having the wrong religious belief. Having no religious beliefs would get you in just as much trouble. And again, so it's very interesting because in those very few words, the writers of the amendment, first they covered governmental control and regulation in religion, and then they basically spoke about the personal aspect of religion and how that would be protected. And again, it's been much interpretation of all this over the years, but very little impetus to change or undo it or to do away with it. Certainly not as controversial as, say, the Second Amendment, the right to bear arms, which constantly comes up generation after generation being discussed. Should we modify it? Should we change it? Should we get rid of it? Should we keep it? No such thing has happened with the religious clauses of the First Amendment. Now, again, we have to go back to our idea that the Bill of Rights applied only to the federal government when it was initially created, and that it was only after the passage of the 14th Amendment that the Supreme Court used the language of the 14th Amendment to incorporate the Bill of Rights into the rights of every citizen of every state, which means that the state governments would also be subject to the Bill of Rights. The First Amendment, in terms of freedom of religion, actually was only expressly incorporated beginning of the 1930s and into the 1940s. Prior to that, it really had been silent. And there were states in Massachusetts, a congregational church was the state religion for many years, well into the 1800s. So it was not adopted very quickly in the 1870s and 80s when the 14th Amendment was first enacted and the court began to interpret it. The idea of applying the religious regulations to the states came rather late. Now, one of the first things that we have to decide is when we're dealing with religion, what are we talking about? Certainly in Western culture, we have organized religions, we have Catholicism, Protestantism, we have the very today evangelical churches that form organizations and have structures, and some have hierarchies and kind of interlocking membership from place to place and city to city. Um, Islam, Judaism also have their own formal establishments, formal texts. But is that all that religion is? The formal and officially kind of seen and known ways of practicing some type of religion. Since the early 1970s, the court has moved sort of beyond that idea of looking at the religion as are you part of an organized church or temple or mosque, into realizing that individuals with certain beliefs, whether those beliefs include the idea of a God or not, whether they participate in an organized institution or not, that they can still be religious beliefs. They can still be deeply held moral convictions, and that these should be protected by the First Amendment to the same extent, in the same way that you would protect the beliefs of somebody who was participating in one of the traditional Muslim, Jewish, Christian religious groups and following their practices. One of the places where this issue first came up had to do with the Vietnam War, as did many things that have affected our society over the last 50 years. Um, During the Vietnam War, the draft was in place. Young men at the age of 18 had to register for the draft, and at 19, they were drafting young men against their will, putting them in the army, training them for a month or two, and shipping them off to the jungles of Southeast Asia to fight this war, which very few people understood and very few people really wanted to be part of. During that time, there arose a movement of conscientious objectors, people who said, I don't believe in this war. I think it's morally wrong. I don't believe in fighting. I don't believe in killing. Now, there had been recognized conscientious objection prior to this. A number of religious groups, such as the Amish and other Mennonite communities, certainly in the Catholic Church, certain orders of brothers and priests, were conscientious objectors and would not submit to being drafted or fighting in war. And the courts had long accepted that and dealt with it as as just part of social reality. But what was happening in the 70s, many of the young men who were coming forward were not particularly adherents to any religious recognized belief or recognized institution, and yet they were claiming that they had this moral conviction that refused to allow them to fight in a war. Your case in these situations were held initially at what was called a local draft board. Every major city and town or county had a group of people who were sitting there in the capacity of deciding who would have to serve and who would not, if you felt you qualified for any of the exemptions to serving, and there were a number of them. You would have to file a petition with the draft board, make your case before them, and then they would decide whether you fit the exemption or not. Well, initially, when young men came before the draft board saying, well, I am not Catholic or a Protestant or a Muslim or a Jew or a Buddhist or any of the other recognized religions, but I don't believe in war and I don't believe in killing people and I don't believe in going in the military. The local draft boards were pretty unanimous in just shooting that down and saying, no, that's not a religion. That's not a religious belief. Show up on the 15th to report for duty. The Supreme Court recognized in this time that you could have a well-founded moral belief against war and that could be protected under the First Amendment even if you were not part of a formal, organized, recognized religious group. Um, there were many attempts in the 1950s and 60s, and some coming up into the 70s, to prevent religious groups from going door to door. A number of religious organizations have a long tradition of going out and attempting to proselytize, which means to convert, to change other people to their religion, to bring other people into their beliefs. And particularly after World War II, as the suburbs began to develop, this became very widespread and was generally disliked by folks, having their dinner or their daytime interrupted by people knocking on the door to preach a homily or a sermon to them and try and convert them to a different religion. A number of municipalities attempted to use zoning ordinances and zoning codes and disorderly conduct codes to prevent this type of activity, and they ought to say that such groups had to be licensed, that they had to submit their materials, what they were doing, their itineraries to the public or to the police department before they would be able to go out and go door to door. And the court was fairly consistent in throwing all of those types of restrictions out and saying that they violated the First Amendment right to speech and freedom of religion, both speech in that you have the right to speak what you believe, and freedom of religion, the idea of trying to win converts to your particular religion, has long been, in at least the Western societies, seen as part of the practice of religion. And the court held that the municipalities could not stop this activity because of that. The court has long made a distinction between belief and practice. So you can believe just about anything you want to believe, as long as and you can speak it, as long as you're not violating one of the exceptions to the freedom of speech provisions of the First Amendment. However, with practices, the court has been more strict in how it applies the First Amendment. The first big issue that came along, and this is that in the 1800s, Mormons, the Church of Latter-day Saints, believed that a man could have more than one wife at a time, and they openly practiced polygamy, which was not condoned by the majority of Americans at the time, and which eventually resulted in their moving to Utah, to the middle of nowhere, as they were driven out from place to place for this practice that the majority of people did not believe in. And finally, as Utah was developed and settled by people of the Church of Latter-day Saints, and wanted to become a state, petitioned to become part of the Union, the Congress required and the court upheld this requirement that they had to agree to outlaw polygamy, that they had to bring their definition of marriage as being only between one man and one woman in their state law in line with the practice of the other states existing at that time and with federal law, or they would not be admitted as a state. And even though there was some protest that this was violating their religious beliefs, the court upheld the government's right to place this restriction on their getting statehood, and the church eventually relented and abandoned the practice of polygamy. In the 1970s, as drug use became rather, recreational drug use became rather extensive for the first time, a number of people started taking up practices of Native Americans and the first inhabitants here of using certain plants that were on the prohibited list, such as marijuana and peyote, and utilizing them, saying that they were part of religious practices, which for Native Americans they were, and even on some reservations there were provisions that allowed these practices to continue. But other people tried to adopt them, saying this is our religious practice, and to bring it back to the regular jurisdiction of the state governments. And again, it was almost universally held that they could not do that. Now, having said that, you get the idea that you can believe anything, but you cannot practice anything. And certainly if your practice comes into conflict with existing laws and regulations, you may be somewhat limited in what you can practice, even though you claim that is a severely held religious belief. But having gone that way for many years, um, the court in 2003 did allow certain religious groups to use controlled substances for their practices. And then a few years later, Miami had enacted an ordinance. There were a number of religious groups in the city that were practicing a religion where they were sacrificing small animals. They were slaughtering small animals as part of their religious practices. And the city tried to pass an ordinance prohibiting that, and the Supreme Court refused to let them do that and said that there was not a sufficient governmental interest there to prevent people from practicing their religion in that way. So the court has gone back and forth on that. Basic idea being, however, if you're, one of the things that I constantly use, if you believe you have to sacrifice a person, a human being, in a ritual murder to the full moon every month, that may be your sincerely held belief. You are allowed to believe it. You're allowed to preach it. You're allowed to try and bring other adherents to believe with you. You are not allowed to practice such a belief in the United States. So the First Amendment free exercise clause does not go that far. We begin to move a little bit and get into cases where it's a combination of free exercise and establishment. Sometimes it's hard to tell which side of the court these cases are being brought on, or which side of the amendment these cases are being brought on, because sometimes they sort of merge. Now, one of the things that everybody talks about when we get into the establishment clause of the First Amendment is the idea, the concept of that there is a separation of church and state. This language does not exist in the amendment. It does not exist in the Constitution. It was language that was in a letter from Thomas Jefferson to a group of people in Connecticut who were somewhat worried that there would be laws passed that would prohibit their particular religion from being practiced. And Thomas Jefferson was trying to assure them that under the new federal government, such things could not happen, and basically came down and said that I look at the First Amendment as if it has created a wall of division separating church from state. That was never a legal concept, although in the 1940s, one of the Supreme Court justices did quote it in a case, so sort of semi-brought it into our legal precedent concerning First Amendment, but it is not the absolute ironclad rule that people think it is. Now, when we talk about establishment of religion, the number of kind of side issues come up that you may not think as being religious at first, but to certain people, they are. In the 1940s and 50s, several religious groups had grown in size to the point where they had numerous children in the public school systems, and they were groups that did not believe in reciting the Pledge of Allegiance. They did not believe in making any type of pledge to a government or anybody else. They brought cases because if you went back from the end of World War II right up into the early 1960s, the Pledge of Allegiance and a prayer was said in almost every public school across the country daily as part of the morning routine to begin the day. Now, schools in the United States, the vast majority of them, when we say they're public, it means they are supported by taxpayer dollars. They are arms of the government. They are maintained and organized by the state or local governments, and therefore, because they are government entities, they are subject to the same restrictions, by and large, that any other government agency would be subject to in terms of the enforcement of the Constitution. So, as we get into the 40s and 50s and 60s, a number of cases are being brought by people who said our children do not want to say the Pledge of Allegiance. We do not believe in prayer. We are atheists. We do not want children praying at the beginning of the day, or we are of this minority faith. We don't want our children saying a prayer from the majority faith. at the beginning of the day. And the Supreme Court was very sympathetic to these arguments. So in many, many cases, the idea of having to say the Pledge of Allegiance, the idea of having to say a prayer at the beginning of the day, of having a reading from the Bible at the beginning of the day, of having a moment of silent meditation, which the court said in itself has a religious aspect to it. All of these things were struck down in various cases. The state of New Hampshire, as its motto, says, "Live free or die." There are several religious groups that believe that that statement is antithetical to their beliefs. And in the 1970s, they sued the state of New Hampshire, and they obtained the right to not have to display that message on the license plates to their cars, even though driving has long been held to be a privilege on state highways granted to you by the state and subject to almost whatever controls the state wants to put on it. The court said when it came time to state certain beliefs and certain messages, if it was antithetical to someone's religious beliefs, they could not be forced to have that happen, to do that. In the military, the Supreme Court usually tries to give great deference to the military in whatever they're doing, whatever they're saying, on the idea that the court does not know and understand or have the ability to micromanage what is supposed to happen in the military. However, and there was a case in the 1980s where a Jewish man, a conservative Jewish man in the military, who would wear a yarmulke, which is a small cap that many Jewish men wear. He was ordered not to wear it. He sued on the idea, saying that it was his religious belief in order to wear this, to be allowed to wear this, that it did not hinder his performance in the military, and therefore the military should not be able to stop him from doing it. The Supreme Court sided with the military in that situation, said no, he could be forced to wear only what the military wanted him to wear. Now, Congress took umbrage with this, and they did change the law to allow members of the military certain discretion in terms of wearing religious apparel, so long as it doesn't interfere with their duties. In dealing with children in the teaching of religion and the practice of religion, the courts kind of go two ways at the same time with this. Certain aspects, particularly when it has to do with the health of the child, the courts are very, very strict. There are a number of religious groups that do not believe in using modern medical science. They believe that when somebody is sick or injured, only prayer should be used to bring about healing. Or they believe that certain types of medical practices are prohibited by their religious beliefs, so that while they may get some medical treatment, certain other treatments are anathema to them and they will not accept them. The courts have long held throughout the 20th century and into the present century that when it comes to children, you have the right to refuse medical treatment for yourself on religious grounds. You do not have the right to prevent your child from receiving such treatment. And the courts have gone so far as to take parental rights away as concerns the medical treatment of their children, and to appoint guardians specifically to see that children get the proper medical care, treatment, and just routine visits to the doctors and whatever vaccinations that are deemed to be necessary for them. Vaccinations have brought up a whole big, nasty fight in this area. There are many people who do not believe in vaccination at this point, believe that they are more harmful than they are effective. There are many parents who do not want to have their children vaccinated, and while in most states there are mandatory vaccination programs for children, and particularly to send children in school, to enroll them in school with other children, there has been a growing movement over the years where states will allow an opt-out for religious or medical or other reasons, so that a parent can basically complete some paperwork and their child will not have to be vaccinated and will still be allowed to go to school. And the parents won't be penalized for failure to have the child vaccinated. This is a very, very sensitive and hot issue at the moment, but because the states are cutting out exceptions to their laws, I don't know of any Supreme Court case that has dealt with this as of yet. It has not come up as of yet. Dealing with COVID-19 might be one of the first areas where we come to find that the government will attempt to impose vaccination on people, and we'll have to see what the court will say about that. But usually that would not be on religious basis. It would be on scientific or other type of health beliefs.